All 3 cases.
That's what it looks like.
I'm gonna type it up just to make it clean, but 6 months revoking term?
That's,
Oh, thank you. All right, I'm doing that right now.
so he asked for 6 months, I'm assuming that's 6 months revoking term.
10-4, I'll type it up now.
keep the public informed. I'm fine with that, just as long as you feed back. That just keeping me in the loop is okay. It's all right?
Thank you, Judge.
All right, Mr. Madden.
Good morning, Your Honor.
Good morning, Mr. Madden.
John Madden here on behalf of Demetrius Warble. This is 23 CF 2473. Your Honor, when my client comes over, if I could just have a second to talk to him. Your Honor, we have reached a plea agreement with the state. My client is signing it now. He will be admitting to the violation, and in exchange, he will be adjudicated guilty, have 11 months, 29 days, county jail. He's got 293 days credit in already, $100 VOP fee, and then his probation will be terminated. If I may approach.
Granted. Any score sheet objections?
No, Your Honor.
And State, the only thing I'd ask is that if you complete the bottom section of the score sheet, we've had some issue. All counsel approach, please.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview.
And Mr. Warble, so you don't think this is about you specifically? It had to do with one of these pieces of paper, but your lawyer will tell you I like to do it once instead of do it over, and that's what, so it encouraged this whole conversation with all lawyers to be sure it was done correctly. Now, you heard, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you heard, you can put your hand down. You heard what Mr. Madden said, and you signed the written plea form.
Yes, sir.
Now, you understand, according to this plea, that you're admitting the violation.
Yes, sir.
And that says to me, Judge, I violated just the way the affidavit report my officer filed says it did.
Yes.
All right. And by doing this, you understand you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And in this case, you'll be adjudicated guilty if you were not previously adjudicated. You'll be sentenced to 11 months, 29 days in the county jail. The state agrees that you have 293 days credit. You'll have the additional fees that were discussed. You may have some other outstanding fees and costs. How much time do you reasonably think you need to pay all those things after you get out? Is a year enough time?
A year?
Yeah.
Yeah, that's enough time.
All right. Mr. Madden answered all your questions about the plea and how it affects you?
Yes, he did.
You satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Anything else for you, Mr. Madden?
No, Your Honor.
Thank you now. Good day. Mr. Rare.
Your Honor, I should just have one on the docket today. It's Caleb Wiggins, 22 CF 385. We're before the court on a motion for early termination of probation. He was originally put on in December of 2022. In the motion, we filed with attachments, confirmation from probation. He's completed all conditions satisfactorily. There have been no violations. He's more than 3 years in. Speaking to the state, Mr. Gomez is handling it from the state today. My understanding is the state does not oppose the defense's motion today.
That's correct. All right, motion's granted.
And Judge, I have a generic vote for that approach.
Granted.
You want to just fill that out?
Nope.
Can I feel the back part of the score sheet? That's the only thing I need.
All right. Thank you very much. Thank you, sir. I commend you for completing all your conditions and ahead of time. And it's not always that the state agrees, and based upon your compliance and getting everything done, they've agreed to do that. Thank you for doing so, and I wish you the best as you go forward.
Yes, sir. Thank you.
All right. Good day.
And Judge, I think Madam Clerk was looking at me. I may have one. I don't know if it fell off. Kiana Red Bear.
Red Bear?
Red Bear with 2 words, not normal spelling. I believe that was dismissed.
I believe there's a no cause filed in that case, Your Honor.
Madam Clerk, you can confirm that? It's 26 CF 64.
Yes, sir. I do see a no prosecution filed on 2/9/26.
Okay, very good.
Perfect.
All right. Thank you,
Your Honor.
Mr. Rea. Good day. Ms. Merrifield.
Your Honor, she got called to Judge Hart's.
Okay.
So she'll be back.
All right, so that brings you up, Ms. Jacob.
Thank you, Your Honor. The first time is Casey Nelson.
Awesome.
Unfortunately, I did not realize that Mr. Nelson's misdemeanor case was still open. It's a resisting arrest charge. He wants to resolve that today. The state was good with resolving it today, but I thought he had already pled to it. I removed it from the score sheet, so I'm going to need a moment to write it back in so that it can be correct and write that on the plea agreement. So can we pass Mr. Nelson for just a couple minutes while I do that?
How much time do you think you need? Do it right now.
Okay, I'm sorry.
No time like the present.
Okay.
That way he can watch over you and be fully advised. Let's get it done.
Thank you, Your Honor. $25 MM 3193 for the minute sheet.
Thank you.
Just for time served.
And say again, 125 mm.
3193. It's one count of a resisting arrest without violence.
And who's the supervising judge? Do you
I
know?
believe it's Judge Ward,
Yes,
which
ma'am.
is why I thought it had been resolved because I didn't have the case. I assumed it would have been mine.
Okay.
Which is on me.
All right.
Apologies.
That's all right, ma'am.
And so as to 25 MM 3193, Mr. Nelson is going to be entering a no contest plea as charged to the one count of resisting arrest without violence. That statute number is 843.02. He'll be sentenced to time served, adjudicated guilty, assessed $270 in court cost, and a $50 cost of defense. As to the VOP case that we're here on in 2020 CF 1180, Mr. Nelson's going to admit the VOP. There are two counts originally. Count one was originally just a jail sentence. So as to count two, he'll admit that VOP, be adjudicated guilty, sentenced to time served. revoke and terminate the probation. He will have 180 days to pay any outstanding costs, as well as a $100 cost of prosecution and a $150 cost of defense. I would just ask that I would just ask that the court give him 180 days to pay all of the outstanding costs now that we've added that misdemeanor in. May I approach?
Granted.
And we have filled out the score sheet and we have no objections.
Okay. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, you've got two things going on here today. We're taking care of them together, but you two different things. You got your VOP and you got your new charges.
Correct.
You understand that?
Yes, sir.
As to your new charges, do you understand that you're pleading no contest to those charges?
Yes, sir.
And that tells me you believe the state could prove your guilt and you're not going to contest that?
Correct.
You understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
As to your VOP, you understand that you're admitting the violation?
Yes, sir.
And that says to me that, yep, I violated just the way the affidavit report says it did.
Correct.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your
Yes, sir.
violation? And the sentence in the violation is time served with the costs that were announced and the 180 days to pay any outstanding costs. And in the misdemeanor, it's time served with the fees and costs and the 180 days to pay that. Is that what you understood?
Correct. Yes, sir.
And Ms. Jaquid answered all your questions about the plea and how it affects you?
Most definitely. Yes, sir.
And you're
Yes, sir.
satisfied with what she's done for you?
Most definitely.
The court will find the plea to be freely and voluntarily entered into and accept the plea with the adjudication.
Thank you.
Thank you. You know, call
You're
out
the-
anytime if I get ahead of you, if there's any questions, if I miss anything, you know, tell me, right? Because I only want to do it once, not do it over, okay? Okay.
Your Honor, the next I have is Matthew Witucky in 24 CF 2710. I did coordinate with court security as the PD's office did inform me on Thursday that, or on Wednesday or Tuesday that they were planning to withdraw. So I did go to the jail yesterday and meet with Mr. Witucky. He is present in 24 CF 2710. Your Honor, there was some confusion because there is a co-defendant in a Walton County case that caused the conflict with the PD's office, which made us think that Mr. Witucky also had new charges. When I went and looked a little further into that yesterday afternoon, I realized that the PD's co-defendant that they have right now, he just got arrested on those charges. My client actually already resolved those charges in Walton County, so he does not have any new charges. But because of that, I had delayed working this case out today in an effort to try and make sure that we weren't going to mess anything up in Walton County. Now that I have a little more information, I'm just going to ask the court move this to next week, to February 19th, to allow us just another week. I think we can get the VOP resolved for Mr. Witucky on that date. That way we can get him on his way over to Walton County to resolve that Walton County VOP. And I talked to him about that yesterday. I told him. He's fine. Thank you. And so, Your Honor, so I would just ask that, I don't think the order has been signed yet, so if the court would just orally appoint me, I know the court has a written order that the PD's office has sent over. I assume I'm either going to get that this morning or this afternoon, whenever the court has an opportunity to sign it. So if the court would just allow me to, or allow the PD to withdraw so that I can be appointed as for today's purposes, and then we can go ahead and move him to next week, and Mr. Witucky and I can discuss getting that resolved before, so he can get on his way to Walton County.
All right, what's the case number from Mr. Witucky?
24 CF 2710.
Yeah, it was signed yesterday. So the PD is withdrawn and you are appointed.
Thank you, Your Honor. And so if we could just move this to the 19th, we should be able to get it resolved for Mr. Witucky.
So ordered.
Thank you, Your Honor. Thank you. So I'll see you then early next week, okay? Probably Tuesday. And Your Honor, that is all I have this morning, if I may be excused.
Madam Clerk, can you confirm that?
That's all she has.
Thank you, Your Honor.
All right, thank you. Mr. Tony.
Good morning, judges.
Good morning, Mr. Tony.
Your Honor, I represent Daniel Busby in case 211 CF 2471. Mr. Busby was not delivered this morning, but we had filed a motion for a pretrial release, and the nature of that is that he has a violation of his monitoring device.
Is it Bisbee?
Bisbee, yes, Your Honor.
Daniel Bisbee?
Yes, BISB
20 to 11 CF 2471.
Yeah, we set the notice and everything for hearing, Your Honor, with the motion a couple of weeks ago. But apparently he was not on the docket this morning.
I'm not sure why. State.
Your Honor, the state objects to the motion, and because the defendant is on violation of probation status, he's a violent felony offender of special concern, and pursuant to 94806 subsection 8D, he's not entitled to a bond until we have an evidentiary hearing and the court decides on the violation of probation.
The problem is, Your Honor, this is a technical violation, and to the extent that my client, we noticed the hearing today, we should have had a hearing today, and Mr. Bisbee should have been here in order to receive that hearing to the extent that the court can make a determination. I mean, this is a matter where there is a 32-minute lapse in the monitoring, and he's basically been in jail now for 2 weeks. A person that's been on probation since 2012.
Well, we can reset this to this afternoon and instruct the jail to bring him.
Yeah, that's the problem. I don't have a conflict this afternoon.
Do we have any clue why Mr. Bisbee was not? What would your disposition be today if we had it?
Clearly, Your Honor, we would ask that since there's no new law violations, there's no violent contact, there's no conduct.
But I think under 94806, the only exception to the hold pending disposition is if it is financial only. That is the only exception that the court is aware of unless you've got some authority.
Well, I have my authority in my at the office, and I didn't bring the full motion to the extent that this should have been easily taken care of. We're talking about a technical violation in this particular case where we could easily resolve this VOP. For 32 minutes, he went unmonitored.
I understand that, but I guess what I'm saying is 94806 says that the only exception for a violent felony offender of special concern getting a bond pending a disposition is when it is financial only, unless, once again, I don't know that there is any new authority that changes that. So,
well, the case law I have here, and it says that as long as he's not a threat to the community and there's no new law violation, that was the nature of the release that we were seeking, that he'd be entitled to pretrial release until a hearing of this matter can be held. An evidentiary hearing can be held. I mean, he's not absconding, he's not doing anything. He's been in this community basically his entire life. He's been at the same residence since probation. And he doesn't pose a threat to the community or danger to the community. And I think those are the standards that we look for when we do pretrial release, even for victims of special circumstances. Special concern, I should say.
yeah, so I'm just reading the statute, which is 948-06-8. D, in the case of an alleged violation other than a failure to pay costs, fines, or restitution, the following individuals shall remain in jail pending the resolution of a violation, and then it lists. The court shall not dismiss the probation or community control violation warrant pending against the offender enumerated without holding a recorded violation of probation hearing at which both the state and the offender are represented. And then E says, if the court, after conducting the hearing required, determines that the offender has committed a violation, so on and so forth, other than the cost, that the court shall make written findings of whether the offender of special concern poses a danger to the community, and if so, yak, 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 and then and if the court has found that does, then the court shall revoke. If the court finds that he doesn't, then he may modify or continue and place the probationer back on community control. So I'm not aware of any case law which would authorize the court to provide for pretrial release pending disposition of the violation, other than a violation for financials only. So if we were here today, it would have to be an evidentiary hearing. And if you want to accelerate that, we'll set it next Thursday for an evidentiary hearing, next Thursday afternoon at, I've forgotten, we're doing 2 o'clock now?
2 p.m.
2 p.m. for an evidentiary hearing on the violation, and we'll resolve the violation then.
Just one question, Your Honor. If I may inquire with probation, if it's enough time for me to subpoena them, I don't know if they require 10 days notice for the hearing. We're trying to set an evidentiary hearing for next Thursday, and Officer Farnsworth will be needed. Is it enough? Would that be enough notice for him? Then it's fine, Your Honor.
That's fine, Your Honor.
All right, we'll set an evidentiary hearing on this case at 2 p.m. next, what day is that? I can't remember.
19th.
That's the 19th.
2/19. and at 2 p.m.
Thank you, Your Honor. That's all I have.
All right, thank you, Mr. Tony. Good day.
You too, Judge.
I did. Ms. Merrifield.
Morning, Your Honor. Brandy Merrifield on behalf of Brandy Owin and 25 CF 1415. Ms. Owin is present, and Judge, we have reached an agreement in her case, if I may approach.
Granted. And is this Mr. Gomez?
It is with Mr. Gomez, and Judge, she is withdrawing her previously entered not guilty plea and entering a no contest plea to the terms listed. It will call, did I not get his signature, Judge?
No, it's okay. We had a discussion about the completion of the last section. Go ahead.
Thank you, Judge. The sentence would call for 90 days of incarceration with credit for all time served. She does have standard court cost. I'm asking for 90 days post-release to pay those or have them go to collections.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. You heard what Ms. Merrifield said on your behalf, and you signed the written plea form.
Yes, sir.
How old are you?
45.
How much education do you have?
I got my GED.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it? And is what you read in the plea form what Ms. Merrifield just announced to me?
Yes, sir.
Do you understand you're pleading no contest to the announced charges?
Yes, sir.
And that tells me you believe the state can prove your guilt and you're not going to contest that.
Yes, sir. Say out loud.
You understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
In this case, you'll be adjudicated guilty, sentenced to 90 days in the county jail, credit for all time served with the fees and costs, and you'll have 90 days after your release to get those paid.
Yes, sir.
Ms. Merrifield answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how she's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you. And if you'll step this way, please.
Okay, thank you.
Prince.
And that's all I have today, Judge.
All right, thank you, Ms. Merrifield. Good day. Mr. Atkinson.
And then that leaves us with free bond. Everything else with Mr. Atkinson's bond is on probation.
May it please the court, Your Honor, Clay Atkinson for the record, here today on behalf of William Scott Wolf on a petition to expunge. That is case number 24 CF 50 for the record. As the order setting the hearing found, the petition is consistent and compliant with 943-0585 and 943-059, as well as Florida Rule of Criminal Procedure 3.692. Based on that and the presumptions created thereby, I would defer to the state if they have any evidence they wish to present.
State intends to traverse or demur the petition?
No, we do not, Your Honor.
Have you submitted an order, Mr. Atkinson?
I have submitted an order. It should have been submitted with the initial petition, I believe, Your Honor.
It's signed.
Thank you, Your Honor.
Thank you.
That's all. I may be excused.
Yes, sir. Thank you. Good day. Mr. Patel.
Good morning, Judge. Jay Patel on behalf of Mario Trujillo. He's I forget what you call that. Is that the funnel?
Say again?
My client's just behind that door.
Give me 1 second. Jay, what was his name?
Trujillo.
I think the language was the fee. Fee, that's right.
Once again, Judge Jay Patel on behalf of Mario Trujillo, 25 CF 2397. We're before the court on a motion to reduce bond. Has the court had the benefit of reviewing my motion?
Yes, sir.
And has the court had the benefit of reviewing the probable cause affidavit?
Yes, sir.
So, Judge, obviously, this is a tough set of facts, and so, you know, obviously we acknowledge that by way of how I drafted the motion to reduce bond. What we're asking for is this court to really take into consideration that this particular set of facts was alarming enough for the first appearance judge to ask for a mental health evaluation. I have not had the benefit of seeing what that mental health evaluation was, but I did note that obviously there was a bond that was later given, and that bond is an extraordinary
You
amount.
haven't had access to that, Mr. Patel?
I've not seen it, and it may be because of when I came on the case. I'm not sure about that.
Would you like to review it now, just to be fully informed?
Yes.
That should be available to you, so I'll be happy to swing this screen.
If I may.
Say what you wish to approach.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire.
Yeah, this is counsel being targeted. It's probably just not.
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured?
Judge, everything in that mental health, in that report that you just allowed us to review is consistent with what I've put in my motion. It's consistent with the conversations that I've had with my client. What we're asking to do is essentially that the great barrier right now is the fact that the bond is so high that it's essentially no bond. And so what we're asking, and in order to put my client in his best position to move forward in our society, is to get him the treatment that has been recommended, but really moreover what he wants to do. And so I would ask that from a money standpoint, I'm asking for somewhere between $5,500 to $10,500, and how that's broken down would be $500 on the misdemeanor, and then either $2,500 on each felony or $5,000 on each felony. In addition to that, and the reason why I'm asking for such a low bond is because, number one, my client has retained me. He's very engaged in wanting to resolve the case, but also we'd be asking that the court consider even a scram alcohol monitor, which would also put the court in a position to know that the community is safe, because a lot of this particular incident is alcohol related. So entirety, what we're asking for, besides the monetary recommendation that I gave, would be to enroll in a mental health evaluation or psychological evaluation, and a substance abuse evaluation, both with the recommended treatment to be started within 30 days of release, or rather, 30 days of release, and then the treatment to begin within 60 days of release. That way it allows providers to, to get him on the schedule, to get a scram monitor placed upon him before he leaves the jail, to abstain from alcohol, and for mental health pretrial services. If the court finds that there are other non-monetary requirements that the court deems necessary, my client's open to that.
State. Your Honor, we would just respectfully request that the bond remain as it is. I'm not going to recite all the facts and probable cause, but I do want to point out just that this was a scenario where multiple rather graphic and detailed threats were made. The dispatchers, he called multiple times. He was warned at one point in time about the misuse of the 911 call, to the point where they actually ended up disconnecting the line with him. And I think that illustrates more of the bogging down that is a danger to the community when one line is clogged up because an individual is calling so frequently and threatening the dispatchers, as well as threatening the law enforcement officers that may actually go out there to assess the situation, handle the situation. And so given the details of the probable cause affidavit, we would respectfully request that the bond remain in place at this time.
And Judge, if I may, and I just want to be clear, we're not contesting the facts here. This is a determination for this court and for my client to take steps toward accountability, and also for the court to recognize that I just don't think it's right that we have a system in which it's built upon bondsmen's making a lot of money, because that's the reality of it. I'm asking the court to lower the bond so my client could then use the money that he would be remitting to a bondsman to help with his treatment. And so I don't believe that the requests that we've asked are unreasonable given the circumstances. And simply put, the jail cannot give the treatment program that my client needs.
And so, did you see the pretrial screening report that ultimately set the bond?
Yes, I did see that.
Okay. And so the recommendation there was to have weekly in-person access the evaluations, take the medications, comply with recommended treatment, weekly in-person reporting, and GPS prior to release. Then setting the bonds.
And Judge, my only thought process on this court not issuing a GPS is that he's not a flight risk. We believe that the alcohol monitor really ensures that this court as it relates to the safety of the community, that he won't be drinking alcohol. And I think that that's the main crux of a lot of this.
So does he live at the property by himself?
Yes, Judge. Well, for the longest time, he was living there with his father, but his father recently passed
Right,
away.
I see that in the
Yep.
report.
So he would just be living there by himself.
Okay.
And Judge, his mother travels back and forth between Okaloosa County and New Mexico, so she lives, they have property over there, in which she's, I think, attending to some probate issues, so she's kind of back and forth.
All right, so I want to discuss some things that they'll be on the record, but I don't want them to be on the public record. If you will please approach.
Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents
So we'll reset this for Thursday, the 19th, with the idea that you'll provide the information that was discussed. And if that comes in sooner, then you can review it with the state, and if they're agreeable, then I'll sign the order. Okay?
And Judge, did you want that, is it okay if I appear later than, like around 10:30?
Yes, sir.
Thursday?
Yes, sir.
Okay.
And once again, as long as you let Ms. Natali know, she'll make notes on my docket. We'll set it for 9 just because that's what we have to do. But as long as you let her know, then there's no worry.
Okay, thank you, Judge.
Communication is important, and letting her know, she'll put it right on my docket for me.
Thank you, Judge.
All right?
All right, I'll be in touch with
Anything else, Mr. Patel? That's it?
you. No, Judge, thank you.
Mr. Ballack?
Morning, Your Honor.
Good morning, sir.
We got Jared Weber, 23 CF 1249.
Yes, sir.
He's here for a VOP. I represented him in Bay County for violation of probation. They decided to reinstate him, put him on CC2. It's my understanding the state's also in agreement. I just want to make sure that it all ran concurrent. CC1. Yeah, community control. Just so that he's not on 2 community controls.
It should. He'll have to be screened here before he leaves, right? But then they'll simply transfer him because he lives in Bay County, correct? But is that right, probation? He'll have to check in with you before he goes back?
Yes, sir.
But you'll just simply tell him he's coming, and they'll arrange that?
Okay.
Okay.
And I have the signed agreement, signed by all parties on the score sheet.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right. You can put your hand down. You heard what Mr. Ballack said, and you signed the written plea form.
Yes, Your Honor.
You understand that you're admitting the violation.
Yes, Your Honor.
That says, Judge, I violated just the way the affidavit report says I did.
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
All right. In this case, was he previously adjudicated? Or is adjudication withheld? Do we know, Madam Clerk?
He looks to be previously adjudicated.
Okay, so he's previously adjudicated. So you'll be reinstated, but the remainder of the supervision will be on community control. The cost of transportation plus the cost of prosecution will be also assessed. Is that what you understood?
Yes, Your Honor.
All right. And Mr. Ballack, answer all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with what he's done for you?
Yes, Your Honor.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, once you get out, you've got to check in Fort Walton before you go back, okay?
I got to check in for Walton probation?
Correct.
Okay.
Before you go on back to Bay County, and they'll make all the arrangements, but you got to check in there first, and he's going to give you a sheet of paper before you leave, giving you instructions.
Okay.
All right.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Ballack. Good day. Safe journeys.
Next, we have Mr. Walker with Mr. McKinney.
Morning, Judge.
Good morning, Mr. McKinney.
Jason McKinney on behalf of King Jesse Walker, 24 CF 2809. This is a felony violation of probation. We have reached an agreement. The agreement calls for Mr. Walker to admit to the violation of probation. He was adjudicated previously. His probation will be reinstated and modified, so the next 12 months will be drug offender probation. Standard curfew of 7 p.m. to 7 a.m. Probation has the ability to modify that for work or school, complete all original requirements, $100 VOP fee, $150 cost of defense. No objections to the score sheet. It does appear that it has been filled out. May I approach?
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
All right. Do you understand by this plea arrangement that you're admitting the violation?
I do.
And you're waiving your right to a hearing where the state would have to prove your violation?
Correct.
And you will be adjudicated guilty. Your probation is going to be reinstated, but modified, so the next 12 months is drug offender probation with the standard curfew that can be modified for school or work, and you've got to complete all your original conditions with the additional fees and costs. Is that what you understood?
Yes, sir.
And Mr. McKinney answered all your questions about the plea and how it affects you?
He did.
You satisfied with what he's done for you?
100%.
Court will find the plea to be freely and voluntarily entered into and accept the plea. He was previously adjudicated, right, Madam Clerk? Okay.
Can you give me a copy? It's okay.
No, they're going to just send it right now, so it'll be you back.
And if y'all have folks in the gallery, we can move on first before we continue with our inmates. Let's get those folks on down the road.
Judge, I can handle one of Mr. Cochran's, which is Jennifer Lample. Ms. Lample is present and approaching.
All right.
Or just leave your stuff there at the bar, okay? Thank you. Keep your hands out of your pockets.
This is set as an early plea in 25 CF 1882. The agreement that's been reached with the state for the early plea is a plea as charged in 25 CF 1882. Adjudication is going to be withheld. 4 years of standard probation, 24 hours of community service work. Restitution is to be paid to the American Legion, and it looks like they're going to reserve up to that amount for 120 days. No trespass at the American Legion. Standard court costs, $150 cost of defense. May I approach with the plea agreement and the score sheet?
Yes.
One moment, Judge.
All right, if you'd raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
I did.
How old are you?
44.
And how much education do you have?
High school.
You able to read and understand the plea form?
Yes.
Do you understand that by this plea arrangement, you're pleading no contest to the charges?
Yes.
And that tells me that you believe the state could prove your guilt and you're not going to contest that.
Yes.
Do you understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt?
Yes.
In this case, adjudication will be withheld and you'll be on 4 years of probation with the fees, costs, and other conditions that were announced, including you cannot be back at the place that was announced.
Yes.
Mr. McKinney answered all your questions about the plea and how it affects you?
Yes.
You satisfied with how he's represented you?
Yes.
Well, and Mr. Cochran too, I
Yes.
guess, because he's substituting for him today.
Yeah.
Court will find the plea to be freely and voluntarily entered into and accept the plea. If you'll check in with probation before you leave, please.
Okay.
Judge, may I call Trenton Lindsay?
Yes.
Mr. Lindsay is present at 25 CF 2083. This is also Mr. Cochran's case. I am standing in for Mr. Cochran, for Mr. Lindsay. It shows on the docket as a motion to suppress. However, there's an agreement that's been reached. Mr. Lindsay at this time would be entering a plea of no contest as charged in 25 CF 2083. We would, I guess, withdraw the motion to suppress for entry of the plea. He would be adjudicated guilty. It would be credit for time served, no probation, $615 in court costs, $150 cost of defense. We would ask for a year for him to pay off those amounts. May I approach the...
Granted.
And, Your Honor, there's a score sheet waiting on the printer. I just got to find some time to write down.
I'll get it. It's okay.
Yeah, it should be there.
Okay. And you've reviewed the score sheet?
The guidelines.
It is a government.
No objections, Judge.
All right. Raise your right hand, Mr. Lindsay. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. Now, you heard what Mr. McKinney said. Now, he's standing in for Mr. Cochran today, and you signed the written plea form.
Yes, sir.
And you also heard, Mr. McKinney, that we're here today for motions to suppress, but instead of that, you've agreed to offer this plea to the court. Is that right?
Yes, sir.
All right. How old are you?
60.
And how much education do you have?
No.
High school?
Graduate high school? What was the last?
6th grade.
6th grade?
Yeah. You able to read and understand the plea form?
Yes, sir.
Okay. Because that's the purpose of the question, not to, it's just, you able to do that. And did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what was just announced to the court? Is what you read in the form what Mr. McKinney
Yes, sir.
just
Yes,
told
sir.
me? Okay.
Yes, sir. I'm sorry.
And so this plea says that you're pleading no contest to these charges.
Yes, sir.
And that tells me you believe the state could prove your guilt as to these charges, and you're not going to contest that.
Yes, sir.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
And you understand by doing this, this waives your motion to suppress?
Yes, sir.
All right. And the agreement here is that you'll be adjudicated guilty, credit for time served, and you'll have the fees and costs that were announced. How much time do you need to get those pays? A year enough time?
Yes, sir.
Okay. Now, is between Mr. McKinney and Mr. Cochran, have they answered all your questions about this plea and how it affects you?
Yes, sir.
And you're satisfied with what they've done for you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Gonna go and get some fingerprints, and then we're good.
Good morning, Judge.
Mr. Koch.
Your Honor, may I call, this is Mr. Cochran's case. It's set for the 1:30, but she's present. May we address that? This will be entering not guilty.
Yes.
And this will be Miss Adrienne Moore. Oh, there she is. Miss Moore in 26 CF 14.
All right, give a chance for Madam Clerk to let me know she's ready,
Yes.
since we're skipping dockets.
This is going to be court date.
Good.
So I just wanted to give you that.
Thank you.
Okay.
Excellent, Judge. Thank you.
Good morning.
This morning, we'll be entering a not guilty. Formal charges were filed. We'll waive formal reading. The current offer, Your Honor, is a 2-year probation offer. This is Mr. Cochran's case, but I did review that with Ms. Moore. We can keep this on the 3-9 pretrial docket at 9 a.m.
All right, very good. Thank you very much. Good day.
Good to go. And now, if I may address my case, Mr. Samuel Strength, who's present and approaching on the 9 a.m. docket this morning.
Good morning.
Good morning, Mr. Your Honorable.
Judge, and this is Mr. Strength, 24 CF 2555. If I have a brief moment for a signature. Judge, Mr. Strength will be admitting the violation this morning. He was previously adjudicated guilty. We are not going to extend his term of probation, but we are going to modify for the next 12 months to be the drug offender probation. This will have the curfew from 7 p.m. to 7 a.m., which is adjustable by probations for work or school purposes. The remainder of his probation, after he does the 12 months drug offender, will be standard probation. And we're going to reinstate all the original conditions, all the original costs. We have $100 for the violation of probation cost prosecution, $100 for defense costs, and there's a $50 PD application fee. If I may approach with the signed plea form, Your Honor.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
You understand that you're admitting the violation,
Yes, sir.
waiving your right to a hearing where the state would have to prove it.
Yes.
And you were previously adjudicated guilty.
Yes, sir.
And in this case, your probation, it will terminate on the same date, but for the next 12 months, you're going to be on drug offender probation with the curfew that was announced. And then, after that 12 months, you revert to standard probation and you've got to complete all the original conditions and with the additional fees and costs. Is that what you understood?
Yes, sir.
Mr. Koch answered all the questions about the plea and how it affects you.
Yes, sir.
Satisfied what he's done for you.
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Okay, very good. Thank you.
That's correct.
And no score sheet objections, Mr. Koch to Mr. Strength.
No objection, Your Honor. And if I could just briefly on the record, my client just asked me about the possibility that after the halfway point to petition this court for early term. I said, of course, at the halfway, if we complete everything, we can always petition and to stay in contact with me. That's always
Absolutely.
always an
Because,
option.
you know, as you saw earlier, when someone was successfully completed, I believe that if you do everything you can do and you do it quickly and properly, that you should be rewarded for doing that. And so if you're able to do that and move forward, then I'll listen to your plea to have your probation terminated early. I mean, that's the goal.
I appreciate the opportunity,
The goal is to get compliance and to move you forward to a different place in your life.
Yes, sir.
And if you do that, I'll reward you.
Thank you.
You're welcome.
Thank you, Your Honor.
Find
Have
the
a great
plea to
day.
be freely and voluntarily entered into and accepted.
Thank you. Judge, that's all I had present in the courtroom.
Now, we have a few other folks in the courtroom. Anyone else here for your own case, or are you waiting for an inmate? Anyone else have their own case? Raise your hand. Okay. Yes, your name right here?
Gerald Vaughn. Gerald Vaughn.
Do you see him on the dock?
They said be here at 9 o'clock this morning.
Do we have a case number, Mr. McKinney?
Not on the paperwork that I'm looking at, Judge. I'll have to look it up.
Look at the other judges, they had a history.
What's the first name?
Gerald.
Gerald.
Vaughn, like in Victor, Aughn.
Looked like it may be on an arraignment docket, but let me look and see.
Okay.
I think it's going to be, it's the 26th, 269, so it's probably
It looks like a TCS charge.
Say again?
I think it's going to be a plea day, Your Honor.
And do you have a case number there?
26 CF 269.
269?
Yes, Your Honor.
Okay. Yeah, that's what I show on the notice, but I think if we're looking at,
What does it say today?
I just don't understand why these documents resolve like this.
The notice to appear that is in the file states March 12th at 1:30 p.m.
Yes, and so
That's okay.
what notice does he have there, Mr. McKinney?
Judge, he has a probable cause narrative. from Fort Walton Beach, and I'm looking to see if there's a date on it somewhere. It does show the appearance in court to be February 12th at 9 a.m. on the probable cause narrative.
I do not see an information filed yet. Well, first, Mr. Vaughn, thank you for responding because the paperwork told you to.
Yes, sir.
That seems to be a mistake on the warrant because your actual court date is on 3/12
3/12.
for arraignment. Mr. McKinney, you have been appointed to represent Mr. Vaughn, at least according to the progress docket. So Mr. McKinney is your attorney. Get in touch with him so he can chat with you about the progress docket. I know the state's not in a position at this time, it's Mr. Snell's case to make an offer, but unless you see some notes there by any chance.
And
Okay.
Judge, there need to be an information filed as well.
Correct. There is no information filed at this time. But get in touch with Mr. McKinney and be back on the 12th. I apologize for the confusion, but we got you squared away now, okay?
Call my office right now, and then they'll get you scheduled to come in and talk to you.
Yes, sir.
Okay. Thank you, Mr. Vaughn. Good day.
You're welcome, sir.
All right, someone else out in the gallery have their own case today.
Your Honor, if I may announce an unrepresented client in the courtroom, or not my client yet, but Mrs. last name Helnitz with a P, first name Corey.
Yes.
And this is 25 CF 575, unrepresented. I'm just going to put your paperwork right back there.
Thank you. You're welcome.
All right. You're here today without an attorney. Do you want an attorney to represent you, or would you like to hear what the state
I do, Your
has?
Honor. Yes, I do.
Okay.
Yes, sir.
All right. Are you able to afford one on your own?
I am not.
All right. Have you completed the application for the appointment of a lawyer?
I have not, but I will.
Okay. One will be given to you right now. Fill that out and hand it back to the bailiff. Don't leave until you receive until you hand it back in and you get a new court date, okay?
Thank you.
You're welcome now.
Thank you.
All right, so,
Let me handle Ms. Hawks first. She's
Hawks?
right here. Aubrey Hawks. This
Good
is
morning.
24 CF45.
yes, I see it.
Judge, she successfully completed the 90-day program, and I think based off of that, the state may have an announcement.
That's correct, Your Honor. At this time, we would be announcing a dismissal of the violation of probation, and Ms. Hawks will be reinstated to complete the original terms of probation, Your Honor.
Just have to complete the original check.
Do you understand?
Yes, sir.
Do you have any questions?
No.
Okay. Thank you for your hard work. I know
Yes,
that
sir.
program is not easy,
It's not.
but thank you, and I can tell from the smile on your face that you're in a different place than you were when we saw you a while ago.
Yes, sir.
So move forward, and thank you for your hard work. Check in with probation before you leave now. They may have some specific instructions for you. And if you've got any other questions, check in with Mr. McKinney, okay?
Yes, sir.
And
All
Judge,
right.
she is moving forward and going in, she's in cosmetology school. She's doing well with that.
Very good.
And I know that in representing Ms. Hawks in the past, employment's always been an issue, so I'm hoping that she continues to do well with that.
Very good. And if you need any, if you need any help with probation, any additional orders for you to complete your school, you just let probation know and they'll discuss that with me, okay? So setting you up for success is important as well because we know that that makes a difference.
Yes, sir.
Okay, thank you
so
for your
much.
hard work.
Thank you.
And Judge, this is Ms. Trawick before the court. This was set over in 25 CF 1636 and 23 CF 180. We'd set today as a status for payment of restitution. I do have the receipt that she has paid the restitution in both of those cases. The agreement that we were working on with the state, I may need just a minute to speak to Mr. Gomez about if we want to call this case back.
Okay. So we just hold on to that so you have a chance to talk to Mr. Gomez.
Yes.
Okay.
And For the record, we had agreed on effectively a 60-day county jail sentence and with probation. She has a medical appointment on the 24th. She's trying to get her disability, so I'm hoping to delay her report date for the 60-day county jail until after the 24th so she can make her medical appointment.
I have no objection.
I'll still need to write up a plea agreement.
Okay, all right.
But it sounds like that we're all on the same page.
Okay, very good. Have a seat, and we'll be back with you in a minute. All right. All right. Anyone else with their own case? Yes.
Oh, I wasn't raising my hand.
Oh,
Sorry.
okay, I'm sorry. I thought you were. Some people
sorry.
get way up there, and other people are just like that, and I thought you were. All right?
No, sir.
All right. So let's take just a 5-minute comfort break, and then we'll, you chat with the bailiff in what order you think you need folks to come out and get them lined up, and so that we can just run down the list, okay? All right, and if you need to chat with anybody, you do that, and just let me know when we're ready, okay?
Yes, Judge.
All right, Mr. Judge.
5 minutes.
Yeah. I don't know. I would hope that the dockets would get better, but they're not.
Give him a minute, he's having a little bit. Is it just a general question?
He's gonna be up in just a minute.
Oh, yeah, she won't talk to me, that's his girlfriend.
Okay.
Because I mean.
That's okay. I'll leave the way for him to get on. I asked for him. That's a statute that allows felony special concern. You call it off for probation. The judge can move back if he wants to, if he thinks you're ready.
Yes, we are.
That's why I have a problem.
Sounds good to me.
So that's why I have to touch base with Warble County and told them, don't work.
We're moving pretty good. Missing Snell and one of our guys, we're doing pretty good. I mean, if Frank could handle, this, I mean, we'd be smoother. Hey, he's not here. He's number 9, though. He's here. Wait, he's driving the bus. He's got to go pick up. Yeah, he did tell me that. So we'll cut him slack. He's got the driving on his mind.
Oh, you're cutting people slack now, huh?
Wow. That sounded so aggressive, didn't it?
Tom is
So angry.
That's
So aggressive. And he has a household with more firearms. Okay. All right. Enough said here. Very angry. Need help writing anything else?
No, I think I'm good on everything else.
I'm gonna leave you alone.
Things come out with this. I always prefer to set it on a court date. But Stone's probably just gonna want to give her a report date.
He's a liability. Yeah. FYI.
Mr. McKinney, do you have just a second?
Very well.
I'm sorry. I didn't drink the whole last night because it's just like this synopsis. Thank you. Sure. I won't bother you no more, I promise.
That's okay.
How long should
You're gonna have to teach me how to do that.
I think 5 minutes. Around 5 minutes.
What? It's not there. I try to do it.
All right. We're good.
And then
Okay.
we're just gonna run down the list.
Cool. I got these 2 pleas and this bond, and I got my people. Hades on top of it.
The audio is still live. Not okay.
Not okay.
I think we're gonna do mine to start off with.
Yeah, I'm ready.
Then I don't know if he's gonna jump into Chris's or yours.
I'm ready to rock.
I think we're ready on everything.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.